Good morning, Mr. Child. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine.
Officers were dispatched to a disturbance at 70 Carlton Woods Creekside. Law enforcement officers observed a white male sitting on the curb of Kukendall Road, arguing with his girlfriend on a cell phone. Law enforcement officers had received an additional call of a disturbance of two individuals coming from a neighborhood party. They observed the complainant and defendant to be highly intoxicated. An Uber had picked them both up, and they both started fighting in the Uber. The Uber drivers pulled over.
Fighting in the Uber?
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was the defendant's girlfriend. And the Uber driver had called the security officer on.
Right off the bat, this case is already wild. Intoxication, Uber mayhem, and a messy assault allegation. But here's the kicker. Even if a victim says they don't feel pain, the court can still infer a bodily injury if the conduct shows it. So pay close attention, because this entire probable cause decision hinges on exactly that.
Duty to get help with the situation. I'm sorry, Your Honor, it's reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Actually, stay close to that area. Don't come here. Stay close to that area.
Okay, sorry.
So we're just doing PC. All I've heard so far is that they're both highly intoxicated, arguing. He's allegedly punching and slapping in an Uber car. That's all I've heard so far.
So then Uber driver pulled over and called the security officer on duty. But the defendant got out and started walking. The security guard followed him until he got to the beginning of the subdivision. Then officers arrived and observed the defendant on the sidewalk. Officer tried to talk to the defendant. And the defendant started to tell the officer, quote, "Leave me the fuck alone. You people are a piece of shit, and that's all you'll do is treat people with no respect." The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they're trying to hide. Defendant said that that's my marijuana. Defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said they were a party, they both got drunk and started fighting when they got in the Uber. And the complainant witness stated that she did not feel pain. And I think that's where we're at.
Do they see any visible injuries, anything of this nature?
As far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically that the punch was of such a force that it caused her to fall to the floor of the vehicle and cover her face after she was punched. I think that's where we're at with that.
Again, to answer your question, there's no indication that there were any injuries at all, any marks, and as he just read, she said she did not feel pain, she did not want to press charges, and I have an affidavit on prosecution as well that I'm going to be getting to the state.
Yeah, so as far as bodily injury goes, of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, a punch of a certain amount of force from a witness's perspective.
Did they get any statements from the person who saw the punch
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
The officer goes to interview the complaining witness, I'm
Yes.
assuming, and doesn't see anything?
I don't see any indication that they saw anything.
And she says, I felt okay. And I do not want to press charges.
Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of a bitch they have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases. You start racking up convictions. All you're doing is you're hurting yourself. You know, be nice and good things happen. You're aggressive to cops. You're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. But don't drink if you're going to be in jail. You know, really. We have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge.
I speak English, sir.
Judge,
You like a translator, or do you speak well enough?
no, sir. I'm good.
All right, Mr. Octaviano, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On April 11th, 2025, in Harris County, Texas, officers dispatched to a motor vehicle accident. Upon arrival, officers observed an individual standing on the passenger side of the motor vehicle talking to several McDonald's employees. The defendant confirmed to officers that he was driving the motor vehicle that was present. Another officer verified the defendant was driving by talking to witnesses on scene who stated that they observed the defendant exit the motor vehicle from the driver's seat and was the only occupant of the motor vehicle. Let's see. The accident occurred in the 10,100 block of Hammerly Boulevard, Houston, Texas. I'm just trying to get some details on the accident, Your Honor. Officers observed the defendants have trouble maintaining his balance, slurred speech, and drowsy eyes. Defendant initially stated he had nothing to drink, then stated he had Buchanan's, but not too much. Defendant stated he had eaten a torta, but could not remember where it was from. Standard field sobriety tests were conducted with the following results: 6 of 6 HGN, 7 of 8 walk and turn, 3 of 4 one-leg stand. DIC was read. The defendant consented to a breath test. 0.202 and 0.195 were the results.
Who said anything about driving? Did anyone?
So,
I know you have the admission, but
right, and they said there was several witnesses that saw him. I'm checking now to get some details on that actual accident, Your Honor.
but you have witnesses that put him driving.
Yes, Your Honor. There was officers there that saw him.
I don't know if those witnesses are named, Your Honor. I haven't had a chance to look at the offense report.
Well, I'll give you time. This is just a probable cause hearing, you know, if it goes, right. Mr. Octaviano, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
Does he have a valid Texas
He does,
license?
Judge.
You cannot drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, do not drive. That is also a condition of your bond. Do you
Yes, Your Honor.
understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but you must stay in touch with counsel and he'll tell you if and when you have to come back to court. For now, we'll have you go sign a reset. We'll have you get with pre-trial for your bond conditions, then you're free to go.
All right, thank you, Judge. And I've got one more arraignment, Judge, but I think we're waiting on DVD on that one.
Okay.
So,
Yeah. Good morning, Mr. Berryhill.
Good morning.
Sir, you're charged with criminal trespass. So you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance call and made contact with the complainant, who stated that the defendant came into his business and was upset that a check issued to him was not good. Upon arrival, the defendant became belligerent with law enforcement officers, and complainant stated he no longer wanted the defendant on his property due to his aggressiveness. Defendant stated he was not leaving until he got his money and was advised 3 times to leave. Defendant refused to leave each of those times and was detained by law enforcement officers.
Mr. Berryhill, I'm going to find that there's sufficient probable cause to go forward with your case. Do not go back to this place. Do not have contact with the complaining witness. Do you understand, sir? Yes or no?
Yes.
Okay. Do you have the ability to hire a lawyer?
Yes, I would like to have a lawyer. I would like a reset, have your lawyer.
Sure. We'll give you a reset now. I'm going to have the state create bond conditions for you. Don't go back to this business. Don't have contact with the complaining witness. As long as you can comply, you and I will be best friends. Otherwise, it's just not going to go well. Do you understand? Don't pick up a new case. Don't become a danger to my city. That's all I'm asking you to do. You understand? So I'll have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and then you'll be free to go. Please. So can you file no contact, no going back?
Absolutely, Your Honor.
You are Mr. Saran. Sir, you're charged with criminal trespass, facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Law enforcement officers received a call for service where an individual stated that somebody was trying to break into her home. Officers observed the defendant matching the description given by a caller around in the area. Officers made contact with the defendant and he was identified by previous booking videos as well as his SPIN number. Officers made contact with the complainant on scene, who advised that the defendant was trying to break into her home. Complainant stated the defendant knocked on the front door, rang the doorbell, and looked through windows of the complainant's property. Complainant observed the defendant entering her backyard, stand on top of a shed to look into windows, and attempt to pull on a door handle to open the door.
And it's only a trespass.
Complainant has surveillance footage of the defendant on her property. Officers searched the defendant and found an unused pipe that officers' training experience indicates it was used for meth. Defendant stated he was a frequent user of methamphetamines. Defendant further stated that during an interview with officers that he was looking for items of value at the above residence in order to obtain money for drugs since he was currently out of money. And I think that the reason it wasn't charged as a bird have is because he wasn't actually able to make entry into the residence.
Mr. Saran,
Yes, sir.
since 2023, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and now 11 in a matter of 14 months. If I find that you're using any kind of dope, I'm going to take care of it in a way that you're really not going to like it. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. You're ordered not to use anything. And if I find that you do, and if I find that you become a danger to my community, I will grow a horn and tails. Do you understand?
Yes, sir.
I'm putting a GPS monitor on you so I know where you are at all times, and I don't want you out in the middle of the night.
Yes, sir.
It's time for you to stop using. I'm giving you now the opportunity to do it on your own. If you're incapable of doing it your way, then we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Please appoint him a lawyer. I'm sending him now for a drug test. You were to go test, and you were to come right back. I just want to know what, if anything, is in your system.
Yes, sir.
If you fail to test, if you fail to come back, I will issue a warrant. No more PR bonds. Do you understand?
Yes, sir.
Take a seat for me. All right. Good morning, Mr. Graham.
Good morning, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
On April 13th, 2025, law enforcement officers observed a vehicle with an expired registration and conducted a traffic stop. Upon contact with the defendant, law enforcement officers observed the odor of marijuana coming from the vehicle. Probable cause search was conducted of the vehicle and the defendant. Defendant stated he was in possession of marijuana, which was found to be 0.524 ounces of marijuana in his pocket. Defendant also stated that he had a handgun in the center console. The handgun was recovered from the vehicle. All right.
Can you run his license?
Absolutely, Your Honor.
Mr. Graham, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm ordering you not to be in possession of weapons. Do you understand?
Yes, sir.
You have the ability to hire a lawyer.
Yes, sir.
Okay, we are going to give you time, so I will have you go to Victoria, sign a reset. We are going to create bond conditions. License?
It's eligible, Your Honor.
Okay, you're not allowed to drive unless you have a license and liability insurance in your name, and that's part of your bond conditions as well. So we'll have you sign a reset. We'll have you go to the box while we get your bond conditions created. We'll have you sign it, and then you'll be free to go. All right?
Sir, thank you.
Please. Thanks, man. Sir, you're charged with racing on a highway. You're facing up to a year in jail And I'm sorry, you're facing up to 180 days in jail and or a $2,000 fine.
Law enforcement officers observed a large group of performance cars gathered at a location and then saw two of the vehicles line up side by side and accelerate to approximately 100 miles per hour. Law enforcement officers recorded the events, and another law enforcement officer initiated a traffic stop where they made contact with the defendant, who was the driver of one of the vehicles that had took place in this outpacing contest. Defendant admitted to being in the races and stated that he never got out of his vehicle while he was at the race.
Do we have a co-defendant in this case?
They're checking now, Your Honor.
And number one, number two, does he have a license?
And check, Your Honor. So the co-defendant is not linked in our system. I don't know if they just weren't able to stop that one.
Right.
But I'm running his license now, Your Honor.
Mr. Barber, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to participate in these types of events again. If I find that you do, first thing I will do is I will put you in jail. And the next thing is I will take away your privilege to drive while this case is open. Do you understand?
Yes, sir.
You're not to participate in any street takeovers, racing, donuts, reckless driving, anything of this nature.
Yes, sir. Can I say one thing?
Do not, don't. Just the only other thing I'm going to caution you is you are not allowed to drive unless you have valid liability insurance in your name as well. If you don't have car insurance in your name, you're not allowed to drive, and that's a bond condition as well. If I find that you do without, I will revoke the bond and put you in jail. You understand?
Yes, sir.
Do you have the ability to hire a lawyer, sir?
Oh, yes, sir.
Okay, we're going to give you time. I will have you go to Victoria, sign a reset. We will have you go into the jury box while we get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Yes, sir.
Please. You are charged with assault of a family member. You are facing up
Puede recibir hasta
jail and or a $4,000 fine.
Law enforcement officer
Okay, pause. The judge is shifting gears from legal analysis to a full-on life lesson. And when judges go philosophical, it usually means they're not impressed with the evidence. What do you think? Should intoxication and a messy Uber fight be enough for probable cause? Let me know in the comments, because this case is about to take a surprising turn.
Los oficiales
were dispatched to a disturbance. Upon making scene,
a la cena
they spoke
y
with
se hablaron
the 10-year-old daughter of the
la hija
complainant,
de 10 años de la fijante,
who stated
que
that her
dijo que
mom
su madre
was hit in the face
le
by her dad.
pegaron en la cara por su padre.
The complainant
La
stated
hija
that she was
dijo que
struck
ella
in the head
en la cabeza
at least 3 times
3 veces
with a closed
con un
fist,
puño cerrado.
while also being
Ellos
kicked
también patalearon
on the side of her
en
torso.
la- su cuerpo.
While this was going on,
Mientras que esto estaba
the
ocurriendo,
defendant had barricaded himself
se vio encerrado
in the children's bedroom
en el cuarto de los niños
of the residence.
de la residencia.
Um, Complainant also stated
También dijo de que
that she was dragged by her hair.
la sujeron de su cabello.
The 10-year-old
La
child
niña de 10 años
observed all of this.
observó todo.
The the complainant
Esa
stated
gente dijo de que
that she felt pain
ella sintió dolor
during this,
durante
but was unable to provide a
y
number.
se pudo dar
on a scale of 1 to 10.
numeración a un 1 a 10.
Yes, Your Honor.
Estaba involucrado algo. Dice sí, sí.
10-year-old witness did advise that the
Niña de
defendants
10 años
had been
dijo
drinking
de
some
que
kind
había
of
bebido
alcohol.
un tipo de alcohol.
Mr. Mata Rojas, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail.
Te voy a encarcelar.
I want you to know that I will protect every person in my county at all costs. I don't care who you are. I don't care why you're here, how you're here. If you're not in this country with permission and you go to jail and immigration finds you, they will possibly put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with.
Hasta que se acabe el caso.
Do you understand?
¿Entiende? Contesta.
Sí,
Yes.
You're not to have contact with the complaining witness in this case. You're not to be in possession of weapons, And I don't want you to go within 200 feet of where she lives or where she works.
Judge,
Su señoría,
it seems like the
Parece
CW is
que tiene
going
que
to
tener
want to protective
tener,
order.
ah,
I've instructed them if they do, we'll have to come to
de
court
vamos a ver
and you'll have to see and hear from her if you
I
consider
think the
that.
allegations are,
Las alegaciones son
There might be some
tal vez
self-defense allegations as
hay
well.
I get it, but all I know is that at this time, Mr. Matarojas, I don't want you to have contact with the complaining witness in this case. I don't care if she comes to you. I don't care if Jesus comes down and says we're having a party and she's there and they want you there. Don't have contact with the complaining witness. Do you
¿Lo
understand?
entienden?
Yes.
Yes.
Judge, if she, after like 30 days, if she wants the protective order removed, would you be open to, if she comes to court?
We'll keep an open mind. I don't know.
Yes, sir.
No sé.
All I want to know is that, number one, he's not using, and number two, that she's protected, and that she feels that she's not in danger.
Absolutely,
Ella no está en peligro.
So, I mean, come back in a while and then we can talk to her and we'll see.
absolutely.
But until that,
Is his appearance waived? I know your rule, but I just wanted to hear from the court.
Mr. Mata, you have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Martinez, and he will tell you if and when you have to come back to court. If Mr. Martinez tells me he can't get a hold of you because you're ducking, dodging phone calls, text messages, or you pick up a new case, I will revoke your bond and put you in jail.
No sé, tú puedes encarcelar.
Do you understand?
¿Usted lo entiende?
Yes.
Yes.
So we have a MOAP that has been already issued in this case, right?
Yes,
Yes,
sir.
sir.
Puesto.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate this protective order, the state can and probably will file a violation of a protective order, and that is one of the worst misdemeanor cases you can pick up. For now, we'll have you go to Victoria, sign a reset. You will then get with pretrial for your bond conditions, and after that, you'll be free to go. Thanks, Herman. Thanks for being patient. Good morning, Mr. Cummings.
Good morning, Judge.
So you're charged with deadly conduct. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 11th, 2025, officers were dispatched to a family disturbance call. Officers arrived and met with the complainant, who was ID'd by her Texas driver's license. Complainant identified the defendant by name and date of birth. The complainant stated that an argument occurred between her and the defendant. The complainant stated the defendant grabbed his handgun and held it in his hand as he became angrier. Complainant left the apartment due to fear. Complainant returned to the apartment and contacted the Harris County Sheriff's Office to report the incident. Officers made contact with the defendant. When officers approached the defendant, he stated, quote, "I'm not talking and I don't want to answer any questions." Defendant began to gather his things and grabbed a handgun and placed it in a fanny pack. Officers drew their guns on the defendant, and the defendant stated, "Are y'all going to shoot me? Shoot me then." Defendant complied with verbal commands and was detained.
Is the brandishing of a firearm enough for a deadly conduct? Because does he do anything affirmative? I guess.
So, yeah, and that's, I mean, I would never a PC hearing, Your Honor. I'd have to do some case law research, but I can see how it's charged is brandishing the handgun.
This is one of those cases where the tone changes instantly. A child witness, a barricaded room, and multiple assaults described. This is the kind of evidence judges treat with zero leniency. Notice how quickly the judge pivots from procedural to protective mode. When kids are involved, everything in the courtroom shifts.
Putting the complainant in imminent fear of serious bodily injury. I think the reason it probably wasn't terroristic threat is because there was no word said.
Right.
It was just grabbing of the handgun.
Let's do this, Mr. Cummings. I'm going to appoint you a lawyer today so we can figure out, because, you know, we get down and dirty with every case because I want to make sure if I find probable cause, there actually is probable cause. So let's do this. I'm going to appoint you a lawyer today, and I'll have him talk to you, and then we'll revisit this PC hearing momentarily, okay? Just take a seat, but don't leave, all right?
Yes, sir.
And we'll have you talk to someone here momentarily. Okay. Good morning, Mr. Martinez. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12, 2025, officers observed a motor vehicle failed to signal a lane change. Officers also observed the motor vehicle's registration had expired in 2022. There was also unconfirmed insurance. Traffic stop was conducted. Defendant was identified by his Texas ID card. Defendant stated he did not have a driver's license nor proof of financial responsibility. Officers learned the defendant was not an eligible driver due to a license suspension back in February of 2024. Officers learned the defendant had 5 prior convictions for failure to obtain liability insurance on his license. Officers asked the defendant if he was aware of his driver's license was suspended, and he advised he was. However, he did not know how it was suspended, saying he was working on his SR-22 and reinstating his driver's license.
Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. I don't care what you have to do in this life. I don't care if there's someone having a heart attack and you have to go save them. There's a burning building and you have to save 50 kittens. I don't care. If you don't have a license and liability insurance, you're not allowed to drive. This is an affidavit that you're going to be signing with me. And if I find that you do, every single time you drive, it's a contemptible action, punishable by up to 6 months in jail and a $500 fine every time you drive. Do you understand? If you want to drive, go get a license, get liability insurance, and I will be doing backflips. So happy I will be to take this off. But if I find that you do, it's really not going to go well for you. Do you understand this?
sir.
You have the ability to hire a lawyer.
No.
I can have you fill an application. I'll take a look to see whether you qualify. Deputy Miranda will give you an application. I'm going to have you come swear to us that you're not going to drive. I'll get you to Victoria Sign a reset, and then we'll have you take a seat. Please.
You're going to file conditions for